Oh, for the one that
I got one.
Yeah,
That's why it's so much.
And then I believe you said, well, it can't get any worse.
The thing go.
What did she lost? Did you stop that, or?
Yeah, she's I mean, she was going, she probably just got pounds down to $1.50. She collapsed the economy, newly sent the UK into a debt crisis, and the National Bank had to step in, and literally at the last minute. That debt, she evaporated.
Okay, we're gonna get started. I don't know, those people, talking all over the company. We can move on into the details. I'm Joe Sanko. I'm Associate Professor of Computer Science at Damon University, which is just north of about 20 minutes from here. I've been involved in this conference for many years, so I'm really pleased to be here again. Welcome to this session. Obviously, we heard a lot about history, but we're going to start, at least at this point, we'll talk a little bit about rights, talk about constitution, just about human rights, and two panelists to try to explore some of these topics. Okay, I'd like to start with the first, Mr. Edward Chui. His topic is the implication of mobility rights and COVID-19, the Canadian-American perspective. Obviously, he's from University of New Brunswick, but what is so interesting is that he's a lawyer. So we've got a lawyer here, a practicing lawyer, as a matter of fact, and he's really very fitting, to speak about some of this topic that we'll be talking about today. And he also, he'll be exploring the Canadian Constitution. For example, he said here, mobility rights under Section 3, I think 6.6 of the Canadian Charter, give rights and freedom to people to mobilize. So obviously, the notion of mobility is in that Constitution, in Canadian Constitution. I never even heard about that in the Constitution, but they're going to try to explore all that to us. Let me see, what else? I tried to get some more information from him, but it seems like he don't want to give me any information as far as his introduction. He also indicated that the courts have had some visitations of these mobility rights in Canada to see how they can bring some light to some of the problems they have. So I'm looking forward to that presentation. Next, we have a next panelist. Her name is Amy Kuhn, L'Oreal University, and her topic is The Trusted Traveler Says Who. She's a fourth-year political scientist major, and we're also looking for her presentation because she didn't give me much to go by. We're pleased to have her. So we're going to start with Mr. Edward Chui.
Thank you. I just wanted to say I also went to Wilfrid Laurier University. I see lots of people from Laurier, so that's where I got my. How did I get the slide?
I think Dr. Risk's got to log in for the computer to work.
I'm on the computer,
Oh,
but the slides don't.
like he showed me earlier. I'll see if I can grab it. So then there's going to be an option.
So don't keep your head.
No going back. You're using this computer or?
It's just. Should be. There it is.
All right.
Thank you so much. Thank you. So my topic is on mobility rates, and I'm looking at the Canadian and the American perspective. So this is me during, and of course I'm looking at what we learned during COVID-19. And I'll explain to you why in just a moment. So this is me during COVID-19 trying to get as close as I can to America, but that's as close as I can get. So just a little disclaimer for you. So this is mobility rights at international law. This is the ICCPR, and you will see that this is very similar to what is in the Canadian Constitution under Section 6. But of course, as we all know, Canada and the United States are dualist systems, so one cannot rely directly on international law. So that's why we need to look at what the domestic law says. So just a note about constitutional supremacy in Canada, just like the United States. It's constitutional supremacy. So in Canada, we look at two main pieces of legislation. Of course, we also look at constitutional conventions and other things, but generally we look at the Constitution Act of 1867 and the Constitution Act of 1982, also known as the Canada Act, because it was also enacted in the UK, and formerly the former legislation was called the British North America Act. So that's our Constitution. In America, of course, as we all know, we have the American Constitution along with the 27 amendments as well. So any laws that are passed by, in Canada, the Parliament or the provincial legislatures, in America, it's the Congress, these laws and the government actions have to be consistent with the constitutional, with the Constitution, otherwise it may not be valid. And a little bit about the common law itself. About the common law itself, it's you know, how it works is we look at cases. Cases we build on cases to learn what the law is, right? So that's why the longer, usually the longer period of time, you have more cases in there, the more we learn about that particular law. One thing we have in Canada is the Canadian Charter of Rights and Freedoms. It's the first 34 sections of the 1982 Constitution, which you see Her Majesty, Her late Majesty, second, and former Trudeau here, Elliott Trudeau, have signed and promulgated in 1982. So this is not too old. This is relatively new compared to constitutions. So 1982 to now is not a long time. So what we're looking at specifically today is Section 6, mobility rights. Just want to clarify, this is mobility rights of Canadian citizens. When we talk about US, we're going to talk about American citizens, but of course, we have so much trade, so much tourists and all that, that the rights of Canadians does matter to Americans and vice versa. So what Section 6 says, and this is the only thing we're focusing on, subsection 1 is every citizen of Canada has a right to enter, remain in, or leave Canada. Okay, so that's protected in the Constitution. Of course, we have subsection 2, which talks about citizens and permanent residents being able to move and to make a gainful livelihood in any province of the country, and then we have subsection 3 and 4 qualifying that. But our focus is on 6.1 today. And so that's what it reads. And this is a very important right, as we can see. However, section 1 qualifies rights and freedoms in the Charter. And that is qualified by only such reasonable limits prescribed by law in a free and democratic society. And what the courts do is they, if there is an infringement of the right, what they do is they look at whether that infringement is by law, whether it's minimally impairing, and then they would do a balancing test. There is a test known as the Oakes test that was developed over time. And so in Canada, we also have something called Section 33. This is notwithstanding law, so it is possible for Parliament, legislatures, and governments to to violate the rights and freedoms by enacting, by stating in the legislation, I am here to infringe the laws, right? But what they need to do is specifically state that and renew it every 5 years. Now, you will see section 2 and So 15 is subject to this, but Section 6 is not. And because Section 6 is not, it is understood as a very important right to Canadians. As you can see here, many academics have talked about that this is a fundamental right to citizenship, one that's very important, equal citizenship across the country, and the objective is national unity, which underlies the charter. So this is a political scientist. And another professor talks, Professor Mendes of University of Ottawa talks about, this writing was in 2020. It was believed that there's a high burden in order to violate these rights. So great caution must be exercised before scientific and public health rationales can be used to restrict these rights. So that was the thinking of the drugs at the time. So before COVID, what we learned is that, a number of things, right? So sorry, this is the Supreme Court of Canada, Justice Laforêt. He stated that the goal of 6.1 is for national community and to protect us against exile and banishment for the purposes of exclusion of membership in the national community. So this case was about extradition. Of course, in this case, the court held that extradition is outside the boundaries of 6.1, and therefore the extradition is, while prima facie not permitted, it is possible to justify that under Section 1. And so this is the dissenting judgment of Justice Wilson, who would have gone further to say that this right allows one to enter or movement in and out of the country according to his own choice. This is a dissenting, so this is obiter, which means it's not binding on future courts, but it's there. Second. Okay, so before COVID-19, we learned that it's possible, it's reasonable for government to require use of passports and IDs, and that it's reasonable for governments to inspect and question persons and search persons and luggages, which is routine. When I came over last night, they asked a number of questions before I was allowed in, so that's normal. And also, if there's suspicion of criminal activity, improper credentials, and all of that, then it's possible to look into these things. And extradition, as I mentioned earlier, a child's right to remain in Canada might be limited if the child was abducted into the country, for example, where his or her parents are not Canadian citizens and subject to deportation. Then if the child needs to leave to live with the parents, then the child doesn't enjoy necessarily the right to remain in Canada. So Delaric is a case where Mr. Delaric is found by Canadian security officials to be a national security threat, also by the United Nations. He was living in the Sudan Canadian Embassy at the time. And the government, based on those advice, have denied him his passport. And the court, and he went to court, and it was upheld that the government must issue the passport to him because he has a right to enter Canada. So this is quite a strong case, which made a lot of speculation about what happened during COVID-19 by academics at the time. Professor Mendes, for example, to help out because this case gives a strong warning to courts, would impose a high burden, and even in the context of a pandemic emergency. Now we'll see what happens after. So there were a number of cases that, and at the time, 2020, there was really no one arguing about mobility rights at the time. And I'll explain why later, but or potentially why. So Turmel and Zabrowski are two cases. So Turmel is he wanted to fly between Ontario to Quebec. At the time, there was a vaccine requirement. Zabrowski wanted, he's in somewhere in South America, or Mexico or Guatemala, and he travels there to work. He wanted to return to Canada, but he was afraid to do so because he was afraid he would be allowed back to Guatemala and to Mexico. on a flight because of the vaccine mandate at the time. And the court held that there's no infringement here. The reason there's no infringement is because, well, two things. The first is that there's exceptions to the vaccine mandate. Second is there's other alternative means to travel. And third is that they're afraid they never actually exercise these rights. And the courts don't rule on hypothetical cases. This is a hypothetical case because he never actually went to take these flights and was denied. Was never denied that, or they were never denied. That's why the court held that there was no infringement. Taylor is a very sad case. Taylor was born in Newfoundland and Labrador. Taylor, she moved to Nova Scotia, and unfortunately, in COVID, her mother died. And she wanted to attend her funeral, that was denied. And she went to court, and this is the Newfoundland Supreme Court, held that this is part of the remain in branch of the 6.1 right, and it was infringed, but it was justified under Section 1. What was interesting about this case is, contrary to what Professor Mendez was talking about earlier, as I explained, it was held that the legislature is not required to provide scientific proof based on concrete evidence of problem it seeks to address in this case, and the court was entitled to rely on logic, reason, and application of common sense that is known, and it looked at these 4 factors. In the end, it was held that yes, she has a very strong case for how it would infringe her ability to go to her mother's funeral, unfortunately, but in the public interest, that was justified. Now, the government, the happy thing is that, well, not happy, is the good thing is that the government did voluntarily let her in after a few days, but the case went on. Spencer is a case of 15 applicants. This was about the quarantine facilities. There are 2 types of quarantine facilities: the government-approved accommodation and the designated quarantine facilities. The former is for asymptomatic individuals, and the latter is for symptomatic individuals. With the DQF, people weren't told where they would be. The individual and the spouse would know where they are, and they weren't told about their right to counsel. It's held that for the most part, there was no infringement here, and these individuals tried to. Most of them came back to Canada. 2 of them were afraid. 2 of them actually came back early. It was held that there's no infringement of 6.1. First, for the 2 people that came early, it's people are influenced by government policies all the time. When they come, for example, the Income Tax Act, that influences people, how long they leave the country, for example. In terms of most of the individuals, they actually returned, albeit they have to live in quarantine hotels. It's a little bit of inconvenience, and one of them didn't go, unfortunately, and suffered, not suffered, but have to pay a fine of $3,000, quite rightly, because violated the act, but that's an inconvenience, and at the end, it doesn't go into the thrust of what 6.1 is about, membership of the national community, because they all came back. There is, however, not Section 6, but Section 9 and Section 10B rights were infringed, because border officials should tell individuals where they're taking them, and also inform them of the right to counsel, because this is indeed a form of detention, albeit for a short period of time. So another case is the Canadian Constitution Foundation and the Attorney General of Canada. So the former was in the federal court. This is in the Ontario Superior Court of Justice. Both are the lower courts. This is 5 applicants, another 5 sad stories, because these individuals wanted to leave the country to visit very ill spouses and parents. One of them wanted to attend a father's funeral in Portugal, but they were deterred from doing so, as they claimed, because of the quarantine hotels. and the cost of it, the court found and held that, well, first, the quarantine hotels are useful because it captures 64% of COVID cases, and that there is a free alternative, albeit not as comfortable as the hotels, but there is a free option, so that there was no breach of Section 6.1, and this court pretty much adapted the Spencer decision in the federal court. So in the United States, it's not as explicit, it doesn't, state mobility rights. What you have here is the freedom of movement. Now, this is found in the Fifth Amendment to the Due Process Clause, which states, inter alia, no person shall be deprived of liberty without due process of law. So liberty is what the courts have looked into, and in the case of Meeker and Secretary of State, Mr. Justice Goldberg, held that the rights, affirmed the court in Kenton Dewey in 1958, the right to travel is part of liberty, of which a citizen cannot be deprived of without due process of law. And the freedom of movement, it is an important part of heritage, and it's both interstate and international. And this case was about whether one can be deprived of a passport because one is part of a communist organization, and that was very broadly defined. And in this case, the court found that it was too overbroad and struck up the legislation. So there's a number, and passports are essential, even in the 60s, to go to most countries in the world outside of the Western Hemisphere. Mr. Justice Douglas, concurring with the court, actually went further to say that, yes, freedom of movement of individuals or citizens is dangerous, but this is what the United States is about, right? We're not a totalitarian state where we ticket and identify people, we're here to their movement and their other rights, just like freedom of assembly, freedom of association. This is a very important right. So I've looked into cases, and I didn't see any that were against the federal U.S. government during COVID. So unfortunately, the law didn't really develop very much. But I think the reason is because I've looked into the U.S. policies during COVID, and U.S. citizens, while there were some restrictions, not a lot, but compared to Canada, but while there were restrictions, U.S. citizens were always exempted. Now, I think that's why there wasn't against the U.S. government, but there were some litigation against counties, for example, for stay-at-home orders. But I think most, if not all, I've seen was unsuccessful. But either way, freedom of movement was not much developed during COVID-19. So what the lessons we learned about this, because as I mentioned earlier, the common law is based on the decisions. So this is why when there's cases, it develops the law. What we learned is that in Canada, in the case of Canada, scholars first believed there was a strong protection, even in a pandemic, that infringement would require very high scientific and public health rationale. But the result was that, no, we saw the court state that this is not necessarily, common sense, and something less is acceptable. We also saw that few citizens have challenged this right, given how many of these rights are infringed. So we can deduct, I think, two things. And even those who were successful, who did challenge, were either unsuccessful or the infringement was justified. So we can deduct two things. Either Canadians are more pragmatic. We feel that public health is important, and you need good health in order to enjoy your freedoms, right? Compared to America. And there may also be a lack of access to the justice system, because as you can see, most of the cases I referred to earlier were either supported by the Canadian Constitutional Foundation or the Canadian Civil Liberties Association. These are governmental organizations. So people mostly didn't really fund these cases ourselves. You know, people come to my office, for example, and we always talk about the legal fees, and that deters us from litigating, because you're talking about at least tens of thousands of dollars to litigate in the lower courts. And all of these cases were in lower courts. None of them were in the Court of Appeal or the Superior Court of Justice. Court of Appeal is kind of like the circuit courts here. And so that's one thing. And the second thing is that might also mean that there might be appeals in the future, or another pandemic, we might have another opportunity to develop the law. So, so this is what we learned, a summary of what we just talked about. That's what we learned throughout this. And yeah, so will there be any future development of the law in Canada? So that's a good question to think about. What I also found, okay, so let me, and so what we learned about the United States is, yes, maybe it's because of the strong culture for freedom, even at the expense of public health, and maybe it's the government at the time, the Republican government at the time, and combined with the strong case law at the time, perhaps made the government more concerned about infringing these rights, which is why, and of course the closest to the election at the time, which is why there was a strong carve-out for U.S. citizens. And one would imagine if there was a different government, a different change of culture, and a stronger pandemic, would that change? And you know, we will need to wait until then to discover what the limits of the freedom of movement is. I'm always really interested in the state model of New Hampshire, live free or die. Well, that shows you, I think, the culture in America compared to Canada. So, so unfortunately for the law, there was not much development there. So I think there was one more thing I had, which is not in there, that I wanted to say is, what's interesting is that in Canada, all of the courts did state the importance of Section 6. It may be the case that Section 6 may not have changed the law very much compared to what the common law is, because, as I mentioned, Section 6 came into place in 1982. Maybe having Section 6 in the Constitution may not have changed things very much. So that may be the case. But that is, of course, for us to see perhaps 100 years or so in the future, and see how the law develops. Thank you so much for your time.
Thank you.
Over here.
Hi everyone. Today I'm going to be speaking about border mobility rights as well, but specifically in a post 9/11 climate and how the idea of a trusted traveler has changed since. So as we know, September 11th, 2001 changed the world. It changed the world's political climate, it created an ambiguous war on terror, and it identified a new enemy to the Western world. Such changes prompted a shift in rhetoric, which now equates border security with national security, resulting in racial profiling and stigmatization of visible minorities, specifically at the Canada-US border. Racial profiling post 9/11 is linked with the practice of terrorist profiling, which refers to terrorism in regard to ethnic and religious characteristics. Such a profile constructs racialized populations, particularly those from the Middle East, as people that need regulation and law enforcement. Thus, a terrorist profile means that racialized populations pose a threat to the general population. The existing research makes it clear that racial profiling at the Canada-US border has been justified and continues to plague visible minorities. While the events of 9/11 resulted in the increased securitization and apprehensiveness towards visible minorities, the blatant racism and profiling of such individuals at the border and beyond the border have surpassed any reasonable or justifiable security methods. Being recognized, whether officially or non-officially, as a trusted traveler should not depend solely on one's race. As will be discussed throughout this presentation, post 9/11 border security has justified racial profiling and racialized what it means to be a trusted traveler, as seen through pieces of legislation linking immigration with terrorism, first-hand experiences of visible minorities at the border, and the widespread propaganda linking these experiences. Unfortunately, in fighting the war on terror, both Canada and the US have increased the reliance on human screening as opposed to technological strategies, ultimately increasing the chances of human error, including racial, religious, and ethnic profiling. My first argument dissects the legislation implemented since 9/11 and how it has linked immigration with terrorism. Significant legislation was enacted in both the US and Canada and between the two nations in the wake of the attacks. And has changed how legislation has been enacted to justify further the implementation of racial profiling in the name of national security. I'll speak specifically on the Immigration and Refugee Protection Act, which I'll be referring to as the IRPA, as well as the Anti-Terrorism Act. So the IRPA, although created prior to the attacks, can be used to understand how racism has been interlinked with immigration and ultimately terrorism. The aftermath of 9/11 has allowed for new enforcement measures in the Act to emphasize security and protection of the border against migrants and those who may look quote-unquote suspicious. Scholars convincingly argue that the terrorist attacks shifted the original focus of the Act from the efficiency of refugee protection acts to national security against immigration, although the post-9/11 IRPA continues to be admired for its new security enactments. The framework of the legislation allowed the government to expand on the basic principles of specific sections, when and if necessary. Many scholars have noted that this ability to expand on sections is problematic, suggesting that government departments have too much power in doing so. This has resulted in prioritizing security while simultaneously constructing migrants as threats. The IRPA has allowed for the construction of migrants as threats and linked crime and security with immigrants and refugees, most likely because they're racialized individuals. This begs the question, would a white migrant and or a refugee receive the same treatment at the border as a racialized migrant? The changes in the Acts make it clear that this perhaps may not be the case, and immigration is very much being used as a tool and front for anti-terrorism. The Canadian government was under pressure from their southern neighbors to legislatively react to the events of 9/11, leading to the new establishment of immigration acts, the IRPA, and was also pressured to maintain trade relations with the US, making Canada more inclined to succumb to the pressures of implementing even more legislation against terrorism. Thus, Canada introduced Bill C-36, known as the Anti-Terrorism Act, on October 15, 2001 as a response, so just about a month later. Scholars suggest that the Anti-Terrorism Act was created to provide the federal government with powers to protect Canadian citizens from terrorist attacks and also demonstrate a political symbolic commitment to the war on terrorism. While the IRPA and Anti-Terrorism Act hold the ability to criminalize the vulnerable, often racialized populations who are entering Canada, they do not consider humanitarian applications in the process. Many of the offenses outlined in these acts carry harsher penalties than the criminal code and carry the same penalty as genocide and crimes against humanity. The willingness to do this reveals the mistrust of racialized migrant populations entering Canada and further the presumption that migrant populations are to be feared and suspicious of. Immigration policy and border control draw upon certain assumptions that have been created about race. The racial profiling and profiling at the border identifies who is trustworthy in society and who is not. These assumptions affect the treatment of racialized individuals, since these populations are the ones that have ultimately been deemed untrustworthy. Decisions made at the border are based on power, characterizing the border experience as one of identifying who are the powerful and who are the powerless. The powerful are perceived as the ones from developed white countries, while the powerless are from developing countries and are typically racialized. The imposition that powerful people are white is derived directly from the colonization of both Canada and the US and the Eurocentric North that have been created since. Understanding the role of race and racial profiling at the border not only highlights the way in which racial profiling is continuously used, but also demonstrates how racism permeates the way immigration and anti-terrorism policy is applied at the border. The aftermath of September 11 ensured the practice of racial profiling was used by immigration authorities and government agencies alike in order to regulate racialized populations. So my next section of arguments provides evidence of first-hand experiences of those who have been racially profiled at the Canada-US border and what profiling really is. Their first-hand experiences of visible minorities at the border in which they were persecuted exclusively because of their skin color, country of origin, accent, etc., provide proof that racial profiling at the border of use in Canada, and especially within airports, is a widespread phenomenon. One scholar, Madani, recalls the time they were forced into surrendering their United States permanent resident card, interrogated for hours, photographed, fingerprinted, and harassed, because they had chosen to be honest and let the border agent know that they were originally from Iran. Their Iranian ethnicity labeled them as a risk to other travelers, and thus a threat to the United States. For years, there have been misconceptions that Canada does not partake in such racial profiling nor racist practices. Since 9/11, Canada has readjusted its public diplomacy to promote its commitments to the U.S. This included implementing a new border security regime in the fight against terrorism that is aimed at improving border security, information sharing, infrastructure protection, and law enforcement cooperation between the two nations. Many cases, especially the widely publicized case of Maher Arar, reveal the consequences of tight securitization of the border and disprove such notions of Canadian benevolence. Wrongful deportation to his country of origin and subsequent torture based on false information that was shared between the RCMP, the Royal Canadian Mounted Police, and the FBI served as an example of how increased measure for border security does not necessarily protect Canadian citizens, such as Arar, and instead created opportunities for targeting those of Middle Eastern descent or other visible minorities. Arar did not look like what a trusted traveler is supposed to look like, and thus eventually faced the consequences of such intelligence sharing and racial profiling at the US-Canada border. Profiling often occurs when a particular group becomes the subject to increased surveillance and when someone's race, ethnicity, or religious background is used as a reason to detain them. Just as Madani and Arar's cases prove, profiling occurs in searches at airports and border crossings as risk profiles for international travelers are constructed by law enforcement officials in Canada and the US. Indeed, the language in which border officials use to characterize racialized people speaks to the generalizations used by law enforcement about these populations, as well as the way they racially profile them, specifically in a post-9/11 conflict. Language such as Arabs and Muslims, when referring to any Middle Eastern people, reflect such narratives about whiteness and stereotypes regarding people of color. My last argument speaks upon the propaganda surrounding Muslim and Arabic people and who is considered risky in following the events of 9/11. Propaganda relies on pre-existing false ideologies and certain ideals and myths, which in this case can be understood as the myth of white innocence and superiority. Such narratives that all terrorists are Muslims or no whites could be terrorists undermine rather than enhance our security. No whites are terrorists is a mistaken belief that ultimately results in blind spots, both in the US and Canada, making them both less safe. When stereotypes take hold, they can be so strong and ingrained in our mind that we may, quote unquote, remember stereotype-consistent acts that did not actually occur. This type of confirmation bias is the same way that the myth of all terrorists are Muslim can be convoluted into an even bigger misconception that all Muslims are terrorists. Scholarship on racial profiling and border control has challenged the idea that such issues are a recent phenomenon. We must recognize the present issues as originating in a white settler society marked by conquest, genocide, slavery, and the exploitation of the labor of people of color. Racialized border practices include a history of dispossession and constrained cross-border mobilities. Canadian and American history has been marked by immigration and migration policies that ultimately favor white immigrants, while only admitting non-white immigrants in response to, for example, the need for labor. The narrative that citizenship is white places non-whites, regardless of citizenship, as outsiders and thus necessary targets for surveillance. Work on contemporary Canada-US border studies demonstrates how the criminalization of non-whites is now part of a broader crime security connection. This ultimately invokes national security as a rationale for racially motivated allowance or disapproval of immobilities. In other words, deciding who is or who is not a trusted traveler. This decision of who is a trusted traveler is evident in US-Canada border spaces as per post-9/11 no-fly lists and other government watch lists in which there is disproportionate refusal of entry for those of color. This is based on no relevant evidence for secondary screenings and traveler rights violations, specifically for those in Muslim or Arabic communities. In speaking upon propaganda, it is imperative to acknowledge that the meanings and structures of race in the US and consequently Canada have changed. Prior to 9/11, Arab was not a racial classification. Arab and Muslim are becoming conflated, and Arab becomes anyone who poses a threat to the US. Some security measures are aimed non-racially at protecting the border and easing communications between Canada and the US in an effort to keep the country safe. Other measures are part of the social structures of the racial stereotypes that we have created post 9/11. Since Arab has become synonymous with terrorist, or at least the potential for terrorism, the logic is that Arabs and Muslims are automatically a natural threat to security. Reliance on human screening rather than technological strategies is problematic. It provides the opportunity for human error, confirmation bias, racial, religious, and ethnic profiling. Securitization of the border is linked to the notion of risk and who is perceived as risky. The way in which racialized populations are targeted by law enforcement officials implies that racialized groups are seen as risky in some way in a post 9/11 climate. The us versus them dichotomy that has been created poses the risky other groups as dangerous and pose a threat to national security. The war on terror has labeled an entire country and race as risky, justifying racial profiling of such people. Ultimately, one's ethnicity and race become a rationale for targeting as long as they identify or look like where they come from, a certain country that the US and Canada have deemed risky. Practices of racial profiling is used not only to preserve, but also strengthen systems of white privilege and social control. The countermeasures in response to the war on terror are not based on the potential for offending, but focus almost solely on characteristics such as birthplace, skin color, religion, and more. To conclude, more focus on implementing security measures based on technological strategies is necessary in order to end the blatant racial profiling that happens due to the human experience of errors and confirmation bias. The idea that a trusted traveler is being defined by one's race is an exceptional demonstration of racial profiling at the border that has been heightened due to the events of 9/11. This includes legislation enacted and the propaganda that has been fueled by both Canada and the United States. The many cases of first-hand experiences of people of color being immediately profiled and having to undergo and withstand such abuse at the border provide proof that these actions, such as legislation and propaganda, have influenced the way in which the post-9/11 climate have impacted specifically those of Middle Eastern descent. Thank you.
Okay, it's time for questions. Or to the panelists. Questions? Oh, the one right here.
Edward, I'm curious about the legalities of the Jay Treaty. I don't get to speak to legal scholars too often. So is that still a legally binding document for Indigenous mobility? And how did that were there loopholes within the COVID regimes that the Jay Treaty may have opened up?
I don't particularly know what know about the Jade Treaty. However, yes, there are, in Canada, we have the cards, for example, that the Aboriginal people, that's what it's called, Section 35, they would have a card, and they can use that to travel across the border. And they would have special rights. For example, sometimes it might be hunting, fishing, and those type of rights across the border as well. So, of course, they're still subject to border controls, meaning they need to identify themselves, answer questions, not to cross the border. But they should have the right, if there's a treaty, they should have the right to enter. And they are citizens of Canada and sometimes in the United States as well. So they still have the Section 6 rights in Canada and the freedom of movement in America, if that's the case. Thank you.
Amy? Okay.
I don't know much about the law in regards to it.
All right. Okay, any other questions?
Edward, this is fascinating. So are we to surmise that not very many people in Canada challenged? So, and we know how much it costs to challenge, no,
Yes.
of course. So if many more people had challenged, like, students petitioning the grave, if many more, not that,
Because that's
yeah.
free, right?
Yeah, it's like if many more people had challenged, where would this have gone? Would the law have developed a sort of a robust response? Or would we have seen that it wasn't really legal to put people in these places? I mean, I say that simply because the Americans then have what they call a carve out for their own citizens, which doesn't make any scientific sense. If we
It does.
are dealing with the pandemic, or current tennis regulations don't let me go. Who's allowed to come to the States to play tennis or not? Sorry, I mean, because that's all.
So I'm interested in that question too, and that's why I
Yeah.
looked into this, you know, I don't propose one policy or another, you know, I do feel that public health is important, freedoms are also important.
But just from a legal
But
perspective,
from the-
we
from a legal
don't have
perspective-
enough people who, for obvious reasons, we know, people didn't challenge it, but because they needed a third party, or another party to finance the challenges. But it's just interesting to see that we're not really sure, as you say, Canadian law is based on series of cases. We need to know each case, that's how the law is made, that's what common law is, but we don't really have that many challenges.
I think
So,
what will happen is not necessarily that the law would change a lot, I think each case, you know,
would have been very significant.
would be significant by itself, and, you know, I think the courts would have more detailed scrutiny of each particular case, and sometimes it's interesting, right? Because sometimes the law might not develop in a logical reason. One court might think this, and another court might
Yeah.
think differently, or the case applied might be very special to that case, and sometimes that's how the law develops. I think it will be very interesting, it'll be very detailed if that's the case, but I wonder what that is too.
Yeah, we don't really have a lot of cases.
So my question then is, even before we get to the case, is where you identified that it never really became too many laws in the States, whereas in Canada there were laws which then were or were not challenged. So my area, I'm not sure today, but is national identity and how do we approach our governments on a different basis, right? And so how did the Americans not even get to the point of any kind of laws to be challenged because of whatever the identity, like, you know, the perception of the people against the government? Whereas in Canada, it did develop to the point of laws that then could be challenged. So it's kind of.
The Americans have laws for non-Americans.
Yeah.
They get made first, right?
Exactly.
Right.
So it's both sides, like the fact that there even was a law to challenge,
Yeah.
but then, do you, or who takes it to that level is the other side.
Well, I think it's the government at the time.
Yeah.
And also, you have to remember that, in America, I think there's more sentiment for freedoms and less for public health, and, you know, that's how the country has developed over time. Right?
Whereas Canada, we accept that there even were restrictions.
Exactly,
Right.
but of course, what was interesting is that, the Freedom Convoy, or so-called Freedom Convoy, in Ottawa, was developed in Canada, so, you know, I
Yeah, so
heard
like
it before, I don't know
Yeah.
how that idea came from. I would expect it from the US first, right? So yes, it is.
Just let me follow up on that, because the carve out for American citizens wasn't watertight.
Right.
In that American citizens abroad until June of last year went to test negative before they were allowed.
June of last year.
Yeah. So then those individuals who tested positive in the airport environment would have to quarantine on their own expense until they tested negative. So this didn't produce any litigation.
My understanding was that that policy, they had to test negative, but they could still board the plane to come and be isolated from other parts of the plane.
My wife spent 5 days in Helsinki.
Yeah.
You have to
Because
know
she
about
tested
this, what
positive.
happened to you, right?
I have the first one. Yeah. So no, there was no,
I
you
don't
couldn't
know,
board the
it
plane.
might be an airline policy, or was it a US policy? I don't think
The
it's
airlines, I
a
don't think, had any, this was a KLM, so it wasn't a.
I don't think it was an American,
Well, no, it was
federal
not.
government policy, was it?
No litigation at all, no.
But I'm there.
Question again, okay, go ahead.
Amy, excellent paper. I'm curious if you found, like the one, many parts of your paper stood, but one part where you said like the no whites are terrorists really, jumped off the page. Have you seen within your research narratives of white violence where terrorism doesn't get used as a term where it probably should have?
I looked a lot, like maybe a specific example at school shooters in America specifically, and whether or not they could be described as terrorists. They're not. I think we all know that. And I think I saw a lot of other examples as well in which white people were doing things that legally and based off the definition of terrorism would be classified, but again, just going back to the idea of like white innocence and white superiority, they're not given that title because that title has specifically been given basically only to people of color, specifically people who look like from Middle Eastern descent. I did a little bit of research on it. I'll definitely have to expand on that because that part was very interesting for me to kind of research.
One example is the 20 Congressional Medals of Honor given to the soldiers at Wounded Knee.
Yes, I think looking at it from an indigenous standpoint, maybe from more of an indigenous standpoint would be interesting. I know I spoke a bit about colonization and how all of this kind of surrounds the idea of Eurocentric norms. But I learned a lot. I know Wounded Knee is a good example. There's a lot of other, like the Dakota, like the mass hanging in Dakota, I think it was.
Oh, during the Civil War?
Yeah.
Uh-huh.
That's also like a widely celebrated event, and it was one of the biggest mass hangings, I think, in North America. I may even say history. So ideas of that as well. Looking at it from an indigenous perspective, I think would be very interesting.
Yeah, another question. I have one relates to racial profiling. I think that's all of us will agree that there is racial profiling. I've experienced it myself. Going to Canada or even to the United States. I'm a doctor, I'm a PhD, but I'll put that same, even my son, of their racial profile. So how do we solve it?
I mean, that's the question. I think the first step would really be getting more strategies that involve technology, like looking at backgrounds. You know, if someone's pulled into secondary, for example, if they have a clean background, and I mean, even you, not that it should be just based upon this, but seeing the fact that you're a doctor, you're a well-educated person and stuff, should be more willingness to kind of let people like that go. But I think just background checks, because basing it only on humans, like I said, the errors for confirmation bias and the errors that could happen just because humans are human and we're not technology that can look at an entire history of a person in 30 seconds. I think that's what needs to be done. It shouldn't be on the border agent to make that decision. We have crazy technology now. There's no reason we shouldn't be able to get someone's background up in 30 seconds.
Everything is amazing, the passport.
Yeah. Even the fact of getting a passport involves getting some sort of background check and such. So if someone were to get a passport, you have to renew it every so often.
Right.
When you get that renewal, if you have a pending arrest or something, you're not gonna get your new passport. So.
I would imagine looking at it from an actual standpoint, by looking at the risk factors of what constitutes a higher risk of a terrorist or someone who is leadership the immigration policy. And if we look at the factors and not the individuals, look at some objectives, that would make it more effective and efficient and less racial profile. That's how CBSA and USCBP work.
Okay, that's good. Any other questions? Okay, thanks for the great job. Remember with the courts, right?
We have a lawyer now.
He will defend us, we got a lawyer. Thank you. All right, so this session is over. Then the rest my bag. I have another. Thank you, guys. Yeah.